In Poweshiek County, case number FECR 010822. State of Iowa is represented today by Poweshiek County Attorney Bart Claver, also Assistant Attorney General Scott Brown. The defendant, Christian Bahena Rivera, appears in person. Should be noted that Mr. Rivera has with him an interpreter, and the interpreter, Mr. Rhodes, has been sworn in by the court. I want the record to reflect as follows, and Mr. Bahena is then also joined by his attorney of record, Jennifer Fries and Chad Fries. File reflects that originally today was the date and time set for sentencing. The defense has since filed a motion for new trial. After consulting with the attorneys, the court entered an order yesterday continuing both the sentencing and the hearing on motion for new trial. And by agreement, we are here today on the limited issue of the defense's motion to compel. File should reflect that the defendant's motion for new trial was filed July 8th of 2021. From the state standpoint, is that an accurate representation of what brings us here today?
I would agree, Judge. We would like to be heard on the scope of this hearing. I think there's a difference of opinion as to what we're going to be discussing today and what evidence is going to be offered. So I'd like to be heard on that at some point.
From the defense's standpoint, do you agree with my recitation?
Yes.
Well, I guess let me, not to cut you off, Mr. Brown, and depending on where we go here, I may give you some latitude to make your argument, but I'll start with Ms. Fries. Again, we're here on your motion to compel. What I anticipate and what I expect from you then is a professional statement as to what you are wanting and why, and then give the state an opportunity to respond, and we'll proceed that way. So, Ms. Fries, you're up. What are you desiring from the state at this time?
Thank you, Your Honor. On July 13th, 2021, we filed a motion to continue hearing on post-trial motions in sentencing and a motion to compel Brady evidence. Essentially, what we are asking for, and I will tell you, we have witnesses and we are ready to proceed with evidence. That being said, I do agree with Mr. Brown that a professional statement of the evidence that we've gathered and what we want may be appropriate. Essentially, this is where we're at right now. After Christian Bahena testified, two people came forward. One person's name was Arnie Mackey. That man is in a conference room adjacent to this courtroom. Arnie Mackey, after listening to Christian Bahena Rivera testify at trial, realized that Mr. Bahena Rivera's statements corroborated a statement by another inmate that he resided with at the Keokuk County Jail. That inmate's name is Gavin Jones. Gavin Jones admitted to Arnie Mackey that he and another gentleman were the killers of Mollie Tibbetts. He also admitted to Mr. Mackey that there was a trap house that was involved and that Mollie Tibbetts was abducted for the purposes of sex trafficking. This man admitted that the story involving Ms. Tibbetts became too big too fast. As the court is well aware and as the evidence was produced at trial, this case had national attention very quickly. That this woman presumably was out for a jog and was just snatched out of thin air. So Mr. McKee comes forward. The information, and this was passed on to the state, but the information that was presented at the trial and that was conveyed to the defense was essentially that some inmate was running his mouth, that another inmate had said something. What we found out after trial is that this inmate identified this Gavin Jones. It has since been linked that they both were in the same jail at the same time. Further, there's evidence corroborating this inmate made statements that he and Gavin Jones were close, and that one of them put money on the other person's books. I believe Mr. McKee put money on Mr. Jones's books, and that has also been corroborated with jail records. So we have a reason to believe that Mr. McKee, the information that he is giving is true. Even more concerning is that at the same time Mr. Bahena Rivera is testifying, later on that afternoon, Mr. McKee comes forward, and within hours, another witness, that witness's name is Lindsay Voss. Lindsay Voss also indicates that the same man, Gavin Jones, that she was his girlfriend, and that Gavin Jones admitted to killing Mollie Tibbetts. It further was corroborated with Lindsay Voss, that she was in a volatile relationship with Mr. Jones, that she sought and received a 236 protective order based on domestic violence from Mr. Jones, that he held a gun to her head on an occasion, and further, there is evidence through a deputy that Gavin Jones was arrested and in the same car with Ms. Voss. So we've got two separate people. Since this information has come together, we have continued to investigate. And through our investigation, through no evidence that's been provided by the state, through our independent investigation, we received a search warrant that was authored in 2019 involving James Lowe. James Lowe is alleged to be a sex trafficker that is in was sex trafficking women out of a home in Mahaska County. James Lowe, even more concerning, a separate woman came forward in 2019 and said that she was introduced to James Lowe at a Casey's in Brooklyn, Iowa. So the same town that Mollie Tibbetts was abducted from. This woman says that she was given gas money and lured to James Lowe's residence that another male and Adam Moshman owns, and that she was put in a room, drugged, and prostituted herself on a nightly basis. So essentially she was drugged to a point that she was not able to consent or not, And it just went over and over and over again. This woman indicated that she was in a room by herself, but that she could hear voices of other women. And she could also hear voices of men and Mr. Lowe talking in the morning saying, "Did you have a good time? Was it worth it?" This woman was deemed credible as law enforcement requested from a magistrate a search warrant, and they were granted a search warrant for James Lowe's residence. There also was information in the search warrant that there was another woman that was attempted to be abducted by James Lowe, and she identified him as 90 to 100% the person that attempted to abduct her. James Lowe is currently in custody. He is currently in custody on federal firearms charges. He was arrested just 2 days after Xavier Harrelson was missing. So the information we have is we have these two people coming forward identifying Gavin Jones. Gavin Jones indicating that he was a sex trafficker for a 50-year-old man, that he was at a trap house of a 50-year-old man. This woman that alleged to have been in this trap house, also involving a 50-year-old man, James Lowe, she was abducted in May of 2018, so just 2 months prior to the Mollie Tibbetts investigation. The Iowa DCI did the interview. We have not received it. It's exculpatory, and we have not received any of the information involving the investigation into James Lowe. There were devices, computers, thumb drives that were seized and that were presumably sent to be looked at for a sex trafficking investigation. That evidence is exculpatory and it has not been produced. Your Honor, I'd ask you to consider this case and consider that we are not in a metropolitan area. Poweshiek County has 18,000 people. Brooklyn, Iowa has 1,700 people. Montezuma has 1,300 people. What information do we have? We have information that 3 people have vanished out of thin air in this small rural county. Mollie Tibbetts, Xavier Harrelson, and the woman that reported being abducted in May of 2018 and sex trafficked. We are willing to consent to any sort of a protective order. We recognize that this boy, Xavier Harrelson, is missing and that there is an ongoing investigation as to who his killer is and what happened to this little boy. We would be willing to consent to any sort of a protective order that the court issues to not disclose any information contained. However, I think that it would be preposterous to believe that the Christian Bahena and the Mollie Tibbetts names did not come up in the Xavier Harrelson investigation. We have 2 people that went missing in incredibly small towns. And all we are asking is that Mr. Bahena be given a fair shot, that through his attorneys, we be allowed to look at this information. We are asking that any sex trafficking investigation involving James Lowe or residents of Poweshiek County or adjoining counties be produced. We are also asking for any pending investigations of James Lowe during the period that Mollie Tibbetts went missing and present. And I note James Lowe is clearly linked to the Xavier Harrelson disappearance. I strongly suspect that he is a suspect and that he is believed to have been involved. But at the very least, he is a witness. James Lowe was on the lam. He was warrant out for approximately a year, approaching May 27th, 2021, when Xavier Harrelson was last reported seen. On May 29th, he is located in Iowa County, and the reason that he's located is that not a traffic stop, not a traffic violation, it is because he is being looked for. And an agent from the Iowa Division of Criminal Investigation, I would assume an agent that is actively working on the Xavier Harrelson disappearance, pulls over a car that has a sawed-off shotgun, and James Lowe runs from that car and runs from law enforcement. He is currently being held on firearm charges in the Lynn County Jail for federal charges. The last thing that we are requesting is any investigations involving inmate 2, who I've now identified as Gavin Jones. We have 2 separate people indicating that he has made an admission to killing Mollie Tibbetts. And I note that Brady dealt with that exact issue. Brady is the case that every defense attorney cites regarding exculpatory information. The facts of Brady involved a person that made inculpatory statements about a killing, and that is exactly what we have here. I agree with Mr. Brown. We have people that are available to testify, but I think that the professional statement stands, and that's all. Thank you.
And Ms. Freeze, I think I'm tracking with everything, but just to summarize, you stand by paragraph 15, and that's the extent of what you're asking for at this point in time.
Yes.
All right, thank you, Ms. Freeze. Mr. Brown, do you have paragraph 15 in front of you?
Yes.
So, you've heard what the defense is requesting. It's the 3 things set forth. I guess I'd like to know the state's position regarding those 3 requests.
We resist providing anything that they're asking for. There is no discovery post-trial. They want to go and knock themselves out trying to find out all of this confusing information that's just been presented to the court. Go right ahead and do it. But there is nothing in the rules, nothing in the case law that compels the state to chase its tail because they're asking us to do it. There's nothing, they want it, that's about it, that's all they're saying. There's no rule, there's no case or anything that would require us to do this. This is newly discovered evidence. This is a motion for a new trial. All right, if they want to try to find newly discovered evidence, they can go and try to find newly discovered evidence. We are under no obligation to go find newly discovered evidence because they want us to go looking for it. There's nothing here that would compel us by rule. The discovery rules are pre-trial, right? And we've complied with those. If there was exculpatory information, even if we learned it post-trial, we would provide it to the defense. We understand what our obligations are with regard to Brady and the cases that have been that cite Brady with regard to exculpatory evidence. We are under no obligation to search for it. This request, Your Honor, is very broad. I mean, it's going to require us to go talk to who knows how many law enforcement agencies. There's no limit on the scope, and there is no law, no rule that requires us to do that. all of the facts that Ms. Freeze laid out that somehow connect James Lowe or Gavin Jones or these other folks to this case, no evidence supports it. None. Zero. There's nothing there. All you have to do is look at the defendant's statement that he gave at trial. The only thing that matches is that Mollie Tibbetts was involved and that at least 2 other guys with ski masks and sweaters and dark pants were the ones that showed up, abducted, and killed her. That's it. There's nothing else about a trap house, Mollie's body being wrapped in plastic, being stashed at a secondary location, that she was tied or bound. There's no physical evidence that was found that connects any of that. All of that's laid out in our resistance. And there's the only thing that's even remotely consistent is that there was a unknown sex trafficker, according to Gavin Jones, or a guy that he was stealing cars for, and that he happens to be 50 years old. Nothing else that would connect James Lowe. There's zero, no evidence, nothing that's there. If they want to go look for it, they can go look for it. They can I suppose ask the court for subpoenas if that's what they want. We've indicated that in our response, but there is nothing that is in the law that would require us to do what they're requesting in paragraph 15. Nothing that I can find, and there is no authorization for that. So if they want to go look for it, you've given them time to search for whatever evidence they want to search for. They can do that. They've got time to do it. We don't even have a hearing set for these 2 motions that relate to new trial that are filed. So we would resist that request. One other thing I want to clear up that Ms. Freeze was the nature of the information that we brought to them relating to Arnie Mackey. We told them as soon as I got it, I mean, it was within hours of talking to him, we took to them much more detail than she's informing the court. I think what she said was that we said that an inmate ran his mouth and said something about, it was a vague statement that she was claiming that we were making. We provided them enough detail that they knew, because Mr. Freeze told me in front of witnesses that what we were telling them was inconsistent with what his client testified to. We told them about the secondary location, that she had been tied up, that another person that was involved. Mr. Freeze told me in front of witnesses that it was completely inconsistent with what his client testified to, and that's why we proceeded. They've got buyer's remorse when it comes to this information. We offered to stop the trial, to go to you and ask to stop the trial, to pursue the information that Mr. Mackey was providing to us. They declined. I left it 100% up to them to do that we would stop the trial and go deploy agents to Mount Pleasant, to the correctional facility, which would have necessarily meant following up with any other information, including what Lindsay Voss would have brought to us. So that was their choice, not ours. They were provided enough detail that they knew that the statement was inconsistent. And you know what? I agree with what Mr. Freeze said back on May 26th. It is inconsistent with what the defendant said. This motion that relates to this other discovery and going on this fishing expedition on behalf of the defense is not authorized by the rules. It is not authorized by the law, and it should be denied in its entirety. That's all I have. Thank you.
Mr. Brown, let me see if I can summarize the state's position then. Regarding the 3 requests set forth by the defense in paragraph 15, the state resists all 3, and the state will not in any way, shape, or form voluntarily provide any of that information to the defense.
No, that is correct.
All right. Ms. Freeze, I'll give you a brief opportunity to respond, and I guess what I would like you to, at least for my benefit, focus in on is the point raised by Mr. Brown that we're obviously post-trial and the discovery rules apply to pre-trial.
I'll respond, Your Honor.
Go ahead, Mr. Freeze.
I understand the discovery rules apply pre-trial and don't apply post-trial. The Constitution applies all the time, okay? And here's the problem with what Mr. Brown says, is that they had a report in April of 2019, okay? And I want to make this crystal clear. In March of 2019, this young woman's walking along Highway 92. She's picked up by a state trooper, an Iowa state trooper, who then she relays this horrific story of sex trafficking in this, it's a trap house, it's a brothel, drug house in New Sharon. This trooper relays the information to the agent in charge of the DCI of that area of the state, okay? Adam DeCamp, okay? So he is the agent in charge of that area of the state. He interviews her, and she relays all this information to him, including that she was lured and trafficked from Brooklyn, Iowa, 2 months prior to Mollie Tibbetts being abducted. Relevant time frame, relevant location, relevant disappearance for a while. She was there not just 1 or 2 nights, she was there for months, Your Honor. So in March and April of 2019, they act upon that information and get a search warrant. They do not disclose that to us. They had that information for 2 years prior to trial. They sat on information, and you cannot get me to believe that the Iowa Division of Criminal Investigation, the prosecution's own agents, didn't at some point talk about the fact that that's odd. We had one abduction in May of 2018, and then Mollie Tibbetts goes missing in July 2018. And didn't think that maybe those two have some connection, or at least that's something we should disclose to the defense, because that could be and is, no doubt is, exculpatory. So, we're going down the same road here. We can't control when exculpatory evidence comes up. Now, Mr. Brown says, he said to me in front of witnesses, and I said what I said in front of witnesses. I take a little issue with what he said and what I said. There was no record made on that. He did say that there's this person at Mount Pleasant, and they were talking about this and that with a possible trap house and an abduction. That's fine. That's fine. At that point in time, that's all we knew. Mr. Brown kept saying, but I want to see the report first. I want to see the report first. And this was after our case had rested, and that's all we knew at that point. Didn't give us any names, didn't give us any more details than that. And hearing somebody from prison come forward watching TV saying, oh yeah, I did that, that unfortunately isn't that uncommon. After the trial was done, the evening after the verdict at 8:00 p.m., we get an email, and for the first time, we are told in a report that not only did this inmate, Mr. Mackey, say this, but he gives names, he gives details, he gives locations, and most importantly, we see for the first time and hear for the first time about Lindsay Voss, who gave the same, or identified the same person on the same day, within a couple hours of Arnie Mackey. That was never disclosed, and we know that was never disclosed because she wasn't even talking to the police until 5:30 p.m. On the 26th. Lindsay Voss's name never crossed anyone's lips, crossed any phone lines, or was sent over the internet until the evening following the verdict. Now, if we'd had Lindsay Voss's statement in conjunction with Arnie Mackey's, and they would have come to us and said, we have 2 people pointing at the same guy, you bet your pants we would have said, stop, wheels. We need to, you run this down. Now they don't want to run it down. After offering it earlier, now they don't have to, they don't want to. There's evidence here that 10 kids in this area have gone missing. We've provided that. There's something rotten in this area. And they don't want to help us or provide us any information. This is a small area. 10 kids are missing. That's not coincidental. And we think it's exculpatory, and due process is the 14th Amendment, and that never goes away. Thank you.
Mr. Freeze, thank you. Mr. Brown, I'll briefly give you the last word on this before I tell you how we're going to proceed.
Yeah, this whole issue that they raised with Xavier Harrelson, that is a pending investigation. The fact that they would put this information in a public document, which we did try to get ahead of, is unconscionable in my mind. And now they want access to that. It's a pending investigation. That cannot happen in this case. There is no connection between anything with Xavier Harrelson and Mollie Tibbetts' disappearance. Wow, is all I have to say is with regard to their request to go down that road. So I'd stand on our written response to this request as well as our previous comments, and that's all. Thank you.
Okay, thank you, Mr. Brown. What I will say is that I understand the request or the three requests by the defense as set forth in paragraph 15 and talked about today. I understand the state's resistance to it. I'll take the matter under advisement and get you a written ruling. I do anticipate that by week's end, I will have a ruling one way or the other telling you what we are going to do regarding the request for motion to compel. So, with that said, while we've got everyone here today, we need to talk I want to talk the logistics of the next thing that needs to happen is we need to get the motion for new trial and motion for acquittal, motion for arrest of judgment set for hearing. I want to hear from each side. I basically have a date in mind. What's the defense thinking?
Thinking about,
When we would set this for hearing?
we're gonna need 6 weeks.
Okay. Defense? I'm sorry, state.
I don't know why they would need that long, Judge. We're available, I would say, week of the 26th, one of those in 2 weeks. I've got some conflicts between the 29th and the end of the week, but I have another trial that's coming up on August the 10th. But in any event, I would ask that it be a shorter amount of time than 6 weeks.
Okay. Mr. Freeze, here's the problem that we have. The rules specify it has to be set within, but not only set, but set, heard, and decided within 30 days of your motion.
True.
So, first off, 6 weeks is out. And I understand what Mr. Brown said. I'll tell you where I'm at, and I want to get then feedback from both of you. Again, understanding what I just said in terms of the time guidelines we're under. I think we need to set this for next Thursday, July 22nd.
I'm in a jury case in Waukon, Iowa that has to go on July 22nd under the sexually violent predator guidelines. Cannot be continued.
Mr. Brown?
I'm available the 22nd, the 23rd. I think the case that Mr. Freeze has with our office, that's an SVP case that thing's been pending for years. Maybe that's why he's got to go now, but it's been continued multiple times before. I don't know why it couldn't be continued again. But the 29th and 30th, I'm out if you're thinking of the following week. We're available the 22nd, the 23rd, 26th, 27th, 28th. I can do it any one of those days.
Mr. Freeze, when does this trial, when's it scheduled to start?
The 21st,
And how long is it projected to take?
the rest of that week. And the reason it has to go is my client has reasserted his right to a speedy adjudication under the statute.
Mr. Brown, give me the dates you're available again.
August 22, 23.
You're talking July.
I'm sorry, I apologize. July 22nd, 23rd. Hang on. And then the 26th or 27th, those would be the 4 days I would be available. I'm through the end of that week of the 30th. That ends in the 30th. Do you follow me?
I'm sure we're gonna have to avoid, the 26th is a Monday, and I'm sure that that will not work.
27th is open. That's a Tuesday.
Mr. Freeze, I guess Freezes, how's his 27th sound?
We can make that work.
Okay. What I will tell you is that court administration, who we have to go through, has told me that the 27th is not available. But I think what we'll do is close the record, go back and jointly call them and see if we can charm them into making the 27th work under the circumstances. So I'll get you a ruling on the discovery as quickly as possible. Again, I don't want you leaving. We'll call court administration once we're off the record. But before we leave the record today, from the state standpoint, anything else we need to address on the record?
No, and the date we're talking about is the hearing on motions for new trial, correct?
Correct.
Okay.
We'd be setting aside the whole day.
I got you.
And then, depending on what happens with that, then we'll worry about sentencing after we've dealt with that.
I understand.
So just the motion hearing on the 27th?
Yes.
Okay.
And did I understand the defense is requesting a full day,
Probably, yeah.
but no more than a full day?
No.
Okay. Well, anything else we need to address on the record?
Just depending on how the court rules, you're probably going to see a flurry of subpoenas out of the defense, Your Honor. I just want to make the court aware of that right up front.
Yep. Okay. All right, well, let's close the record and we'll go back and get a hold of court administration so we get this date set. Thank you.